Hello, how you doing? Thank you very much for popping by. Now, I'd already recorded this today, but I did something wrong with the sound, even worse than usual, and I've had to do it again. But I'm glad about that because in the meantime, I've watched Adrian down with the tower. He's one of those regular cart crashers, the unwitnessing at the cart chaps. And he had a great one today. It was fascinating. He was met with a barrage of umbrellas. You'll have to watch it. It's brilliant. And he's had the police called out on him a lot of times. Um, Jehovah's Witnesses talking about their First Amendment rights, but Adrian knows his better. And I wanted to draw everyone's attention to this article that was published today in Forbes. That's Forbes.com. Is that Forbes magazine? Excuse my ignorance. Which goes into the First Amendment, and it also relates to a landmark legal case, a legal precedent that was set up by a Jehovah's Witness who was acting very Jehovah's non-witnessy, in a Jehovah's non-witnessy way back in the 40s. And it's kind of fascinating. The irony of all these things is always intriguing for me, and also just for any of you in the US going out car and witnessing, just to know a little bit more of your rights, just in case it's anything new to you. So here we have. Now this does talk about the problems that are happening on campuses around the US, or at least in some places in the US, where speakers on certain subjects who advocate certain lines of thought are being blocked from taking part in debates, getting blocked from speaking about their thought processes, whether that's right or not under the First Amendment. And of course, that very much relates, in my mind, it related to people like Stacey, particularly Stacey Lopez and Adrian, who have gone on to campuses and spoken to the Jehovah's Witnesses. They don't like it and they call the police. The Jehovah's Witnesses do it, and it all goes crazy. The most famous one being Tracy. In one day, got the police called on her 3 times, and it's like, Jehovah's Witnesses, you guys have some of the best civil rights lawyers in the US working for you. So come on, you know enough that they can tell you, just don't call the police out. Just don't call the police out. So let's get into this. Okay. So you can see the heading there, the right to disrupt free speech on campus. It doesn't exist. When students and others disrupt events where speakers are trying to make arguments they dislike, they always say that their conduct is justified. Most commonly, the disruptors maintain that they are merely preventing hate speech. Now, I did also want to relate that to well-intentioned people who see someone unwitnessing and then come up to the unwitness saying, you're harassing them, and they have in turn gone on and reported them to the police. And I can get where they're coming from. I can get that. But of course, they don't know all the facts and all the back and forth. So this might be useful if you are confronted by someone reporting or complaining about your unwitnessing. So this preventing hate speech allegedly doesn't enjoy the protection of the First Amendment. Therefore, they are perfectly free to keep speakers they oppose from being heard. In fact, they say they're acting righteously by protecting against speech that supposedly leads to violence or oppression. Student zealots, I don't know if that's perhaps a bit of a biased word, and if you can't be zealous as in your student years. When can you be zealous? It should be an ideological time. You're fired up. You should be fired up. Such as those who prevented University of Oregon President Michael Schill from giving a speech, believe that. So evidently do some college leaders, as we read in this article. So you've got blue links there if you yourself want to have a good old look. Oh, is an advert for Cartier. How did I get that? I thought these adverts were normally primed for your shopping habits. I've never shopped at Cartier, for goodness sake. Anyway, just in case there's any burglars watching this. Their argument, however, suffers from two fatal flaws. The first flaw is that the First Amendment contains no exception for hate speech, in quotes. It reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's not sounding good, perhaps, for those wanting to bring down J-dubs. I don't know. Perhaps you'll have a load of counter-examples of that. Or abridging the freedom of speech or of the press. Well, the press, certainly at least since Obama's time, have been, well, it tightened up at least in Obama's time, have been locked up for speaking out and speaking up with facts. So, First Amendment, Schmamendment, I think. Or the right of the people to peaceably assemble. So why have they got pepper spray? Sorry, I'm seeing counter indications of this. And to petition the government for a redress of grievances. Sounds idealistic. Does it happen? I would suggest not, but I'm not living there, so I may be talking complete poo. Nothing in that language suggests that government officials are entitled to make an exception for speech they regard as hateful. Now, here we get to the lovely J-dub bit here. But another J-dub bit, but isn't there an exception for, in quotes, fighting words? In the 1942 case, Chaplinsky versus New Hampshire, the Supreme Court enunciated a narrow category of speech that is not covered by the First Amendment. Under Chaplinsky, speech that either incites immediate violence or consists of words that by their very nature inflict injury is not protected by the First Amendment. Wait for it. I just love this. The case involved a member of the Jehovah's Witness sect. Did you not mean cult sect? Who was convicted of disturbing the peace for, for having yelled at the sheriff that he and the local government were fascists and racketeers. I love it. I wonder if he stayed a J-Dub for the rest of his years. That's a feisty chap. So, back to Carty again. Hang on. Students and college officials have... Go away. What is... Oh. Students and college officials have often justified their actions to silence speakers by claiming that they are simply preventing speech that could lead to violence or contain words that are inherently injurious. That justification, however, won't hold up. But as Sean Clark explains in his Fire essay, Misconceptions about the Fighting Words Exception, the Supreme Court began to back away from Chaplinsky just a few years after announcing it. In 1949, a case came before it, Terminiello versus Chicago, that seemed to fall easily within Chaplinsky, rather than a single angry man. Sorry, it still tickles me. He wasn't Derek Ahare's dad, was it? Sorry, Derek, you know I love you, but I couldn't resist. Had they invented megaphones then? I'm sorry, I'm off, aren't I? In Term in Yellow, we had an angry Catholic priest who denounced Jews at a large event organized by Christian Veterans of America, where a large number of protesters outside the hall were throwing rocks. Fighting words? Unquestionably so. Nevertheless, the court reversed Term in Yellow's conviction. Justice Douglas wrote the majority opinion, stating the function of free speech under our system of government is to invite dispute. It may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. Speech is often provocative and challenging. It may strike at prejudices and preconceptions that have profound unsettling effects as it pressures for the acceptance of an idea. Clark points out that in a string of subsequent cases, the Supreme Court continued to retreat from Chaplinsky, even though it never expressly overruled that decision. He concludes, either as a result of confusion or bad faith, many administrators ignore the modifications made by the Supreme Court and continue to use the original holding as a legal justification to censor offensive, vulgar, and profane speech. Oh, you fascists and you racketeers. It's fantastic. I think he got the racketeer word from Rutherford, didn't he? Snare and a racket. And just this June, the court again affirmed that there is no First Amendment exception for unpopular speech. UCLA law professor and First Amendment scholar Eugene Volokh, writing on the Washington Post following the court's decision in Mittal versus Tam, the Slants case, don't know anything about that, noted that in Supreme Court jurisprudence, viewpoint discrimination, including against allegedly racially insensitive viewpoints, is constitutional. And this no viewpoint discrimination principle has long been seen as applying to exclusion of speakers from universities, denial of tax exemption to non-profits, and much more. Therefore, neither campus officials nor students have any legal grounds for preventing or disrupting speech because they say it has fighting words, again in quotes, that could be offensive to listeners. Then it goes on against into another argument as well. That's is that another Cartier advert? Whoa, oh my goodness sake! So you've got that. You can have a look at that if you wish. The whole Forbes.com, and then there's links. I'm just very unfamiliar with American law and terms and how you guys work. I have just a sort of a passable knowledge on certain aspects of UK law. But so some of you may say, well, what this writer's saying is rubbish, or it has valid, it has credibility. I don't know. You have it there. You can look at it. I just do love the idea of this Chaplinsky J-dub yelling and hollering. I just love it so much. Well, that was a toodle amount of fun, and thank you so much, Adrian, for your video today. It was a corker. So everyone, thanks very much for watching, and hope you've been having a great week, this first week of January, and lots of love, and bye for now.